This episode is brought to you by SS&C Mineralware. Are you managing mineral assets and feeling overwhelmed? Unsure if you're getting paid what you're owed? SS&C Mineralware is here to simplify the management of your minerals, royalties, and non-operated working interests. Mineralware's out-of-the-box features give you the tools you need to visualize and keep track of all of your assets in one place. Mineralware lets you know in seconds where your interests are, what's active, what acreage is open for lease, and if you're getting paid what you're owed. With Mineralware, you can even automate your revenue and JIB processing and eliminate tedious manual data entry, allowing you to focus on more pressing issues. Thousands of mineral owners rely on Mineralware to keep their mineral management simple, automatic, and all in one place. Take control of your mineral assets today with SS&C Mineralware. To see a demo, you can visit their website at www.mineralware.com. That's mineralware.com.
Are you ready to make the most of your oil and gas mineral rights? Welcome to the Mineral Rights Podcast. Get the knowledge and resources you need to manage your minerals and royalties. Here is your host, Matt Sands.
Hello and welcome to the Mineral Rights Podcast. I'm your host, Matt Sands, and I'm joined by my co-host, Justin Williams, and we're here to help you make the most of your minerals and royalties. In this episode, we're going to talk about marketable title versus just getting into pay, right? And what does that mean? What are the differences between having marketable title and actually getting paid royalties on a small interest? We'll talk through all of that, but before we dive in, there's 2 episodes we've covered this topic and different aspects related to it. One of them is episode 85, where we interviewed attorney Rick Winblad on the concept of probate versus marketable title and all of those things and what you need to do to go through probate to get marketable title. And then we also talked about it in episode 311, which is probate and inherited mineral rights. And we talked about some of the alternatives to probate to get title to interest, which we covered at a high level, the concept of an affidavit of heirship and determination of heirship at a high level. But today we wanted to go a little bit deeper and really focus on the distinction between getting paid and owning clean title to minerals. And Justin, I know you've dealt with this pretty extensively with your family's interests and have gone through the hoops and dealt with these 2 concepts. And it's kind of a tricky, nuanced area for sure.
Yeah, it really is. And I think it can be referred to in a lot of different ways, which can be confusing for mineral owners. And we mentioned marketable title, but you can often hear people say doing it right, going through all the hoops, making sure you cross all your T's and dot all your I's. But really what they're saying is going through the motions with an attorney to ensure that you have marketable title, filing what you need to in the county records, and all those fun things, which isn't always the same, Matt, as getting paid on an oil and gas well, which I think many mineral owners don't realize that. They think once they start receiving that check, they're entitled to it, they own it, but operators have a different bar that they're trying to reach to pay you and ensure that they're not legally liable for paying you incorrectly, in a different bar for marketable title. Or let's say I'm going to purchase the property from you and own this. I might hold you to a higher bar of ensuring you've done everything correct as far as the property ownership goes.
Yeah, that's an important distinction because marketable title is actually a very tried and true legal concept. It's really referring to absolute and unquestioned legal ownership where there are no gaps, there are no liens, there are no competing claims on that property. And it's really the standard that you would need to have in order to sell a property for fair market value, for full price to a buyer so that they have confidence that they're actually buying what they think they're buying and they're getting title to that property. The concept is slightly different when you talk about defensible title. Maybe it's a reasonable claim that you may have title to that property, but there are probably still some defects. An example of that would be that there's a very clean heirship, right? So you have somebody that died without a will. They had one spouse, they had one child. You're that one child. Both parents have deceased. And so by state law, in this specific example, the state says that you would be the heir to that property. And so it's a very clear pathway to ownership. It's just that you haven't maybe gone through those hoops haven't gotten a determination of heirship, haven't gone through probate to clear up title and to actually get the property in your name. But it's very clear that you're really the only possible owner in that scenario. And so that might be something where a buyer would be willing to purchase the property from you and then do the curative work on their side as an interested party, and they would pay for the heirship proceeding and get that all cleared up and adjudicated so that they actually have marketable title going forward. But it is something where, you don't actually have it, but it's pretty likely that you're the only owner. And obviously, the thing that we're talking about today is not so much the things you need to do to get marketable title to be able to sell a piece of property. It's whether you're able to get paid either via leasing a property that you don't have title. You're not the owner of record. If you were to do the title search in the county, let's say the property still shows up in a relative's name, for example, but you're getting approached to lease the property, or you're getting approached, or you've contacted the operator to get put into pay status, and they're requiring you go through some very basic steps to file a few things with the county in order to get that to happen. And we'll talk about what that is. But Justin, you want to talk about why operators might decide to pay you anyway if you don't have marketable title?
The operator's goal really in that situation is to review the title and to protect the operator, ensure that they are paying the correct people, but that they're not paying the incorrect people. Their internal question will be, will anybody credibly sue us over this payment, or could potentially contest that payment, or that ownership was their ownership? Does this family have title that'll hold up in 20 years? That isn't the question necessarily that they're really talking about. They're really it's a materially lower bar, and really comes from a liability standpoint on how certain they feel if you're the right payee for the ownership. Attorneys review the chain of title. They look at gaps and clouds. They're looking at hundreds of owners in some cases in the United States, and they're looking for unrecorded deeds, probate, and they're giving recommendations to the operator. However, the operator has a level of liability or risk to take inside of that, and operators kind of fall on a different level in how much risk they're willing to take. We've talked about suspense a lot, Matt. So if the operator feels like the title isn't clear, they may put that interest in suspense and require you to do some different exercises or paperwork, or file some different things to ensure that you are the correct person to pay. But this isn't necessarily always something that gets filed in the county. This could just be, in the private interaction with the operator.
Yeah, and it's important to understand that being put into suspense, it's not penalizing you. They're not taking money from you. It's really just putting that money in escrow or putting it on hold to make sure that they're not going to cut the check to the wrong person, because there's liability for them. If they do that, they have to make, the rightful owner whole, and it creates all sorts of issues and can cause some legal headaches for them if it's a big enough payment. So, that's why they're doing it. They're really protecting their interests and making sure they're paying the rightful owner. And so, like Justin said, you can sometimes use some cursory ways to get paid royalties. And we'll talk about what these options might be able to do and what they won't do. And it, of course, will vary by state. And so we'll talk about some of the most common oil and gas producing states. But just know that, like we're talking about today, this is not intended to be legal advice. You really need to get help from a qualified attorney in the state where you own minerals to really understand your specific situation. But we're just providing this for informational purposes to give you some food for thought, some questions to ask your attorney as you're weighing options, or questions to ask the division order analyst as you're having those conversations with them to understand your options and the cost benefit analysis of it. Because, in some cases, the interest is so small that going through probate is actually going to cost more than the property's worth. So you might want to be looking at some of these other options in those cases. And the first one we'll talk about is an affidavit of heirship. And like I talked about earlier, we've mentioned that concept in a couple of different episodes. So again, go back to episode 85 or episode 311 to hear a little bit more about this document. And basically what it is a sworn statement from a disinterested person who knew the family, and it's identifying the legal heirs and, the relationships, how many kids they had, how many spouses. And this is where you lay out all the family laundry, right? It's, you had multiple spouses. That's where you need to lay that out. You had multiple kids under different spouses. That's where all that needs to be mentioned. And the whole purpose of that is that it's evidentiary. It's something to provide evidence that this is the situation that person left when they left this life on earth here. And here are the heirs, and here are all the potential people that might own property, this property. And it's really, again, just to provide evidence absent having probate. And probate is, again, something we talked about in those other episodes. It's where you go through and you get title adjudicated. It's where it's definitive to determining who are the rightful heirs. And it is something that's required when you have a will, right? So it's something that you have to go through, and it's basically making sure that the person's estate is being settled in accordance with their wishes as documented in the will. And in the case where there's not a will, this affidavit of heirship might be a useful tool to demonstrate that you're a rightful heir to that property. And of course, the legal weight that this thing will hold is very dependent on the state and dependent on time. And we'll go through a couple of those. So first is Texas, where an affidavit becomes basically definitive evidence of the facts that are stated within 5 years after it's filed. That's not 5 years after death. It's 5 years after that affidavit is recorded in the county. And so in some cases, operators will pay on a properly prepared affidavit before that 5-year period. But again, it be dependent on their risk tolerance, how big of an interest it is, what's the risk if you're the wrong person, and that comes to light later. That's really the case in all of these different states, what the risk tolerance is of the operator and really what the financial liability is there. The next one is Oklahoma. And in Oklahoma, an affidavit of heirship can get suspended funds released in many cases, and it may even support a new oil and gas lease. But again, it has to be on file in the county for 10 years before it demonstrates marketable title. And that's only, again, if the state has no will. And that's, something that is, not hidden. It's no undisclosed will. So it's the thing that you've done all the research. There's no will that you found. And this is really the only option absent, going through probate and having the state decide based on the laws of intestate succession. In other words, the laws of who gets the property based on property code versus a will if there's no will in place. And again, if you open probate down the road, that subsequent court decree, an heirship decree or a probate decree will override any affidavit. So, just know that it's not like a final decision. It's like you can play the trump card later to get that thing overruled if there's further evidence that comes to light down the road. Similarly with North Dakota, and it's something where, you can accept it and it'll be used, and particularly in cases where there, evidence of multiple generations that you're just trying to clear that up. And it's, again, small estates otherwise be uneconomic to go through probate. Same with New Mexico. And that's called an affidavit of succession there instead of an affidavit of heirship. It's a similar concept. And then one interesting note here, Colorado is one where it has to be on record for 20 years before it can be accepted as evidence of heirship. So, that could be a long period of time. And if you're sitting there trying to get paid, royalties, it's something that if the operator is waiting to have that on file for that time period before they'll accept it, then, you might as well go through probate at that point or go through a determination of heirship. But the key thing to remember here is it's not a one size fits all tool. And even within a state, not every operator will accept it, right? So it's something to keep in mind. And particularly if it's a high value property, then it does make sense to go through probate because there's a lot more at stake. It's just really those cases where, the cost of probate, maybe $3,000-$4,000, whatever it ends up costing, for a simple probate, and the property's, a tenth of a net acre and in an okay area, but not like a crazy valuable area, then it's going to be more costly to go through probate than it is to look at some of these other options. So that's really the situation. And then there's another concept called muniment of title. Texas is a specific thing that's used there. Justin, you want to talk a little bit about that and kind of your experience or understanding of that concept?
Yeah, it's a Texas only probate shortcut. So Colorado, I think, has something similar in that there's two different types of probate you can go through based on what the estate owned, and then if it's going to be contested or likely to be contested. So rather than appointing an executor, the court will simply admits the will to probate as evidence of ownership, which then gets recorded as a link in the chain of title. It's available only when there's no need for an ongoing estate administration, which generally means no unpaid or unsecured debts. And that application must be filed within 4 years of death under the Texas Estates Code. So, Matt, this is, I think, a situation that may or may not apply to mineral owners in different situations. And in Colorado, for example, there's real property limitations. And in Texas, I believe it's more value-based. But either way, it's something that is a Texas-only trick. But this is, again, when we say that it's really important to talk to an oil and gas attorney in the state where the minerals are. This is the reason why, because all of these little tiny details can add up, and they will be well versed in handling those. Matt, another good thing that I've learned in working with operators, when you have this sort of thing, you can ask the operator what it is they're looking for. Are they looking for an affidavit of heirship? What is it that they would accept? Even when you go down into documents, you can ask them, what language are you looking for to ensure that we rectify this title issue?
Yeah, that's a great point. And that's really the cheat code to all of this is before you start going down one path or another, thinking that this is what you need to do, is to really ask the operator what they're going to require. And if they would accept an affidavit of heirship, if that's something that is possible in that state where the oil and gas interests are located. And that may be a very short conversation. They may say, yes, for this particular interest, it's small enough, there's low enough liability, what we would accept that. And that would be, maybe the path to go down. But again, really having that conversation with the operator, that owner relations department, and or the division order analyst within that operator will tell you what you need to do according to that operator's risk tolerance to get paid royalties. And so that's really the cheat code, I think, that you need to do first. And then once you learn about, okay, well, we would accept this in this situation, and this is the limitation, or, this is what you need to do and why. And then you can understand the pros and cons of these different options. And, perhaps the affidavit of heirship is something that you could do, but then you still have to wait that time period before it becomes evidence of title. And you're waiting that 5 years or maybe even 20 years in the case of Colorado, because that's really your only option. And that's just something you're willing to do. And so that's something to consider. Now, I will say that so David, who's a listener of the show, and we met at a narrow convention a couple of years ago, and he explained, what he's doing for a bunch of small interests that he has inherited in Colorado. And they're all, in areas where there's not a lot of production, so there's not a lot of value associated with them. But he wants to, reclaim ownership of them and clear up title. And so he's going through probate and filing all the paperwork himself, right? So he's not paying for an attorney to do it. And I think he had an example, some of the probate forms and some examples to go by, and is using that to file probate on his own without the help from an attorney. So there's nothing to prevent you from doing that now. It's just obviously the process is technical from a legal standpoint, and most of us, don't have the knowledge or experience to do it. And so that's why we hire an attorney, so it gets done correctly, and then we get actually what we think we're going to get. But in some cases, if you're a DIY legal expert, so to speak, and you're willing to put in the work, it's possible to get those things cleared up on your own. And it's just spending a lot of time in doing it rather than the money. And if that's something you're interested in doing or willing to do, then it is a potential option. And so that is one example where I know somebody that has done that and actually going through the process to get marketable title on their own without the help from an attorney, just because of the nature of the properties. They're so small and not worth a lot that it would be cost prohibitive to pay an attorney to do it. And so that's the other potential option. And that's really why we advocate, having interests in a trust or an LLC and keeping them as whole, and so they're not subdivided and split up into very, very, very small interests that you're forcing your heirs to deal with this situation at some point in the future, because it's really inevitable. Even if you own 100 net acres today, if you have 5 kids and you're giving those minerals, an undivided interest to each of those kids, and they each have 2 or 3 kids of their own, that all, over a couple of generations, all of a sudden those interests that were substantial and meaningful to you, are going to be worth a lot less to your heirs. And that whole probate process and getting marketable title, every one of your heirs has to go through that process on their own eventually, once they inherit it from your kids, which are, going to be the next chain, the link in the chain, so to speak. And so it's something that by the time you get 2 or 3 generations down, if you multiply that cost of probate over, 5, 10, 15, 20 times, all of a sudden that becomes a lot of money that you're spending on legal fees, and spending that money up front, just a fraction of that up front to establish a trust or to put it into an LLC and create a operating agreement with the family members as having, their different shares that's lined out in the operating agreement, might be a better option. And then you totally avoid probate by those particular legal vehicles because you have other ways that heirship is dealt with within the legal documents that establish those entities. And so you can avoid the incremental cost of each generation having to go through probate. You just deal with it up front, and then there's some adjustments that can be made to the trust, and you have to pay. There's pros and cons of those, and obviously get with an attorney to understand the benefits and drawbacks of each of those different options for you. But that could be another way to avoid this difficult situation and costly situation that you're eventually going to be putting on your heirs to deal with.
Right. It really can create a reoccurring situation. And it has a couple consequences that people may not even realize. The fractionization, Matt, like you mentioned, it becomes really hard to justify the cost of going through these motions. And then also, you may not really get the weight that you deserve in being contacted or found to be paid on the property, which I think is another thing that happens to a lot of people. The marketability gap is something that I think surprises folks. So, so you've got with an operator, you've done an affidavit of heirship, and then you decide you want to sell this property down the line. Just because you're paid does not necessarily mean that the property is owned. And Matt, this can vary by state, like we've talked about. But even if operators accept an affidavit and start paying, the owner may not legally own the minerals until a deed or that probate actually transfers the title. That cloud can complicate a future sell. It can be a reason they don't necessarily reach out to you. It can create a lot of issues. So it's something that is worth cleaning up in certain scenarios, not always. And we'll talk about that a bit later, Matt. But Oklahoma has a 10-year example, and it's the cleanest illustration of just because it's paid doesn't mean it's owned. It could be collecting checks for years while still not holding the marketable title for that property. Buyers apply the higher bar, not the operator's bar, and they pay a premium for marketable title. It lowers risk on the buyer's side. It could be lawsuits, disputes, or even costly curative work like doing a termination of heirship or other curative work. And that defensible title can mean that you're getting a discounted offer, or when you go to close on the property, there's going to be other issues that come up or costs that were not foreseen originally. If you've got multiple heirs and multiple generations, it can really compound it. One heir's incomplete documentation can hold up the payments for the whole family or even for entire generations later. And Matt, in my chain of title, that's the case where it's actually a previous ancestor. It creates a question, and it's something that we seem to have to rehash very often and try to correct, but that question continues to come up. The affidavit of heirship isn't necessarily a shortcut. It is a great tool. I think it's commonly used. But again, it's a different bar that you're meeting than that marketable title that you may need to work with an attorney, get documents filed, and ensure that everything is squared away in the county courthouse.
Yeah, that's a great point. And there's a few specific cases that we'll go through that of when you cannot use an affidavit of heirship. And so the first one is if there's a will. So affidavits of heirship generally apply to intestate succession. In other words, when there's no will and who the rightful heirs per that state's estate law. And if the deceased left a will, the will ultimately should control the disposition, and that must be probated for the title to pass cleanly. So if you have a will, unfortunately, the affidavit of heirship might not be an option. Then, like Justin mentioned, Texas, for example, will allow you to use a muniment of title, which is a streamlined will-only probate. So if this is a very simple estate, there's no debts, like Justin mentioned, and you have a clean will, it might be something you can just record it and go on, and that'll be used to help through this very simple and streamlined probate process. And other states have a similar thing in terms of a streamlined probate for small estates. And then the other thing is, if there is any sort of dispute over the ownership of the property, then you can't use an affidavit of heirship. So, for example, if an heir disagrees about who or who is not a proper heir, who's a child, who's married or not, if there's some uncertainty around that chain of title, that becomes problematic when it comes to an affidavit of heirship. And in that case, obviously a formal probate, and or you might need to go through a quiet title suit. So I had that happen with a client where we were helping them sell their interest, and there was question about a deed or an assignment that was recorded that conveyed interest to a few of the siblings, but not all of them. And it turns out there were like 3 or 4 half brothers or sisters. And so they had to go back, and we had to file a quiet title suit and give notice to those other potential heirs that, if they wanted to contest this, that they had the opportunity. Fortunately, it all played out like it didn't affect the sale at all, but it is something where you have to go through that process if there are other heirs or if the family facts are contested. If somebody was left out for one reason or another, in that deed, even though they should have gotten title to it, it is something that you might have to deal with. And so those are the types of situations where, unfortunately, those affidavits aren't an option, and you would have to go through those other processes to get marketable title. But, the ultimate thing before we wrap up here, I think that, some examples of when the affidavit of heirship or a shortcut like that, a quote unquote shortcut, is actually a potential option or maybe a good call. And like we talked about, I think if you have small, scattered, low value interests, and if you have to do that in multiple states, for example, you have these interests that are in multiple states, you're going to have to do probate and then get ancillary probate in every one of those states. And so there's some incremental cost in every one of those cases. In some cases, if you have a very small interest, maybe you can go to that state and just file an affidavit. And it's not a one size fits all thing, of course, as to what the option is, but it really is something to consider. Again, it really boils down to, I think, a cost benefit analysis of the whole process. And again, it's something that it's a placeholder, I think, is a good way to think about it. It just puts everybody on notice that you believe you're the rightful heir, but it's out there, to be contested until a certain period of time passes, like we talked about. And it could be, if the value goes way up, all of a sudden, you had an affidavit in place for an old vertical well that was only paying $25 a year, and the operator was fine with that potential financial liability. But all of a sudden, it's really sort of a substantial interest, and a bunch of horizontal wells are getting drilled, and there's thousands or tens of thousands of dollars on the line. They might say, well, we know we were paying you on this other one, but for you to get into pay status on these new wells, we need more than just the affidavit in place. And so that is something that could transpire. It just really is up to the operator as to the level of liability they want to deal with. And the other benefit of it, I would say, that is that you are findable, right? So particularly in cases where multiple generations have passed. For example, maybe your grandparents are the ones of record as owning those minerals, but you are the rightful heir. You're the only heir to that interest, because both your parents have passed and there were no other, aunts and uncles or anything like that. Well, it's very much a case of, if it's a very small interest, the operator may or may not go through the trouble of trying to locate you. It may be that they just go through the force pooling process, and your interests are force pooled, and it's just listed there under your relative's name. And if you eventually go and try to claim it, then they'll deal with it. So if it's something you want to be found when that property is drilled, particularly if you're in an area where there's some level of leasing and drilling going on, and it's a very small interest. Filing an affidavit of heirship puts your name and address into the county's records, and so that a landman and operator can actually find it for future leasing or pooling. And so in that situation, that might be a good way to go to, even if you're not getting paid royalties and you're not trying to get into pay status, you're just trying to establish that you're the rightful owner, because then you sort of put your the flag in the ground and says, okay, we're the ones that are claiming this interest. And then the operator can know how to get a hold of you, how to contact you. And so it could be a useful thing from that standpoint. Justin, do you want to talk about a few other practical tips for our listeners before we wrap up? And then we can kind of go to the summary here.
Like we mentioned earlier, talk to the operator. If you're in this situation, they're a great place to start on what they're looking for, why it is that they have questions. We've mentioned it before, but we probably don't say it enough. Asking the operator for a redacted piece of the title opinion when there's an issue like this can be really invaluable, both for speaking with your attorney and understanding exactly what it is that they're trying to solve, and then speak with an attorney in the state where the property is located. It's specifically an oil and gas attorney, or one that's really comfortable with minerals. They'll often know the best scenarios, how long things will take in your area, what's the best way to go about it. It's really worth knowing. And if you're just starting out, you really need to be able to have a savvy conversation with the attorney, with others, the people that you're involved with. So if you don't know anything yet, look at Matt's Mineral Management Basics course. It's a great place to start. And then the National Association of Royalty Owners can be a great way to find good attorneys in your area. So Matt, those are kind of the closing things there. But this is something I think that is ongoing. And if you can do what you can to firm this up, it helps future generations. And again, just because you're receiving that check and you're receiving a check in the mail, it really means the operator is comfortable paying you, but not necessarily that your title's clean, or maybe there's not something you need to do to transfer a title to your name or into your estate. So this is a great thing to mention too, Matt, in part of your estate planning process or to your estate planning attorney.
Yeah, it's a great way to wrap it up. And so just remember that if you are dealing with potential sale, if you have a new generation of heirs that are, not too far down the line, or, if there is rumblings of some oil and gas development, and it might be worth looking a little bit deeper at getting marketable title. But again, it really just depends on your specific situation as to the cost versus how much is that property's worth, as whether or not it makes sense to do it. But like Justin suggested, having a conversation with a qualified attorney is a great place to start. And as always, we'll link to the resources mentioned here in this episode and some other things where you can learn more about these concepts that we talked about. And then we'll link to a bunch of the other past episodes where we talked about probate, marketable title, and alternatives to that, and then also division orders, title searches, because all of this is tied together. And usually when you find out about a property, it's when you're contacted by an attorney or by a landman or somebody that's wanting to purchase your interest. And of course, if you're looking to sell, they would want to have marketable title. But maybe you're getting contacted to lease, and you don't have title, and you need to go through this process trying to figure it out. Whatever the case, if you're just in that situation, trying to figure things out for the first time, know where to go to look for records, where to find more information, highly suggest my Mineral Management Basics course, where I teach you how to do a title search. I talk about in depth the different types of oil and gas interests, how they're related, how they're different, how to identify where there are wells getting drilled in your county, and is it near your property, and all of that and more. And so go to mineralrightspodcast.com/courses to find out about that. But as always, look for this episode if you want to find links to the resources where you can learn more. So thanks again for listening. Thanks, Justin.
Thanks, Matt.
Thanks so much for listening to the Mineral Rights Podcast with your host, Matt Sands. Don't forget to subscribe and share at mineralrightspodcast.com. The Mineral Rights Podcast should not be construed as investment, legal, or tax advice. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy.